Hello, welcome to our channel Unique Law Adda. I'm Advocate Babita Shukla, and once again, welcome back to our comprehensive series on Sexual Harassment of Women at Workplace Act. We have navigated the formation of the internal committee and the intricacies of inquiry process. Now we arrive at a critical juncture. What happens after the IC report is written? This is where the law demonstrates its enforceability and balance. Now let's understand Prevention of Sexual Harassment, Chapter 8, Section 21 to 30, POSH Act 2013. Chapter 8, Section 21 to 30. So, what does Section 21 says? Committee to submit annual report. 22 says employer to include information in annual report. 23 says appropriate government to monitor implementation and maintain data. 25 power to call for information and inspection of records. 26 penalty for non-compliance with provision of act. 27 cognizance of offence by courts. 28 act not in derogation of any other law. 29 power of appropriate government to make rules, and 30 says power to remove difficulties. Now let's discuss about the background. In this detailed breakdown, we will discuss about section 21 to 30 of chapter 8. We will not just read the sections but understand the procedural nuances, the intent behind the penalties, the extensive duties placed on employers, and the supervisory role of the government. Most importantly, will ground check each concept in pivotal case laws that shapes how these sections are interpreted in real world scenario. So let's begin. Section 21, the right to appeal, a substantive check and balance. So section 21 says it's a cornerstone of natural justice. It provides a remedy against a potentially erroneous decision by the internal committee. Key elements: who an aggrieved person. So who is an aggrieved person? The act defines three categories. First, the aggrieved woman. She believes that the recommendations are insufficient or punishment for the respondent is too lenient. Second is respondent itself. If she or he is found guilty and believes the findings are incorrect or the punishment is disproportionate. And point number 3, employer or the employer disagrees with the IC's recommendation. For instance, if they believe the recommended action against the respondent is too harsh or beyond their powers to execute. Timeline and appellate authority. So the appeal must be filed within 90 days, 3 months from the date of recommendation. The appellate authority has the power to condone a delay if appellant can show sufficient cause for not filing within this period. The appellate authority is a crucial point. The Act itself does not explicitly define the appellate authority for the private sector. It states that an appeal shall be made to the court or the tribunal in accordance with the service rules or to be designated authority has led to some ambiguity. For government employer, it's typically a departmental head or administrative tribunal, but for the private sector, it is often interpreted to be the court of the competent jurisdiction, usually a civil court or the high court under its writ jurisdiction. Now let's understand by case law. Mrs. Rupali, DEB versus Ministry of Defence and ORS, Central Administrative Tribunal, CAT. So the case is fundamental to understand the scope of an appeal. The CAT can hold that the appellate authority is not merely a reviewing body. It is not confined to checking if the IC's procedure was correct. The authority has the power to reappreciate the entire evidence presented before the IC. It can look into the merits of the case, evaluate witness statement, and come to an independent conclusion on whether the allegations of sexual harassment are proved or not. This means the appeal is a de novo Latin maxim, which means anew, from the beginning, or a fresh consideration in essence. The appellate can argue both on facts and on law. So, what is the essence? That appellate authority can argue considering the facts also and whatever is mentioned written in the law. So both, balance of both, has to be judged by the appellate authority in finding the truth. The precedent ensures that the IC's power is not absolute and is subject to robust judicial oversight, protecting the right to all the parties involved. Now, let's understand what is covered under section 22, 23, 24. The triggers of penalties, a three-pronged approach. These three sections create a framework of accountability with distinct penalties for different failures. Section 22 defines penalty for employers for non-compliance. If employers does some non-compliant activity, so under 26 penalties for employers are written. This section targets the employer's inaction. The penalty is triggered not for the act of harassment itself but for the failure to implement the IC's recommendations. So what is the scenario? The IC recommends a salary deduction for the respondent or a paid leave for the aggrieved woman, and the employer refuses or neglects to act on it. What is the penalty? A fine which may extend to 50,000. Repeat offence. If the employer has previously been convicted of an offence under the Act, the punishment for subsequent violation is more severe. Fine which may be doubled the punishment prescribed, so up to 1 lakh rupees. Cancellation or withdrawal of his license or registration required for carrying on his business or activity. Now, what is there under section 23? Penalty for malicious or false complaints. So this is perhaps the most sensitive section in the entire Act. Its misuse can create a chilling effect, deterring women from coming forward. Therefore, its application must be extremely cautious and narrow. So, the threshold is high. The ICs must arrive at a positive finding that complaint which was made with malicious intent or not, or the complaint which was made knowing it to be false, or any witness produced forged or fabricated evidence. So, the crucial distinction is the inability to substantiate a complaint or provide adequate proof does not equate to a false or malicious complaint. The burden is on the IC to prove the mens rea or the guilty mind, the intention to malign, harass or cause harm to the respondent. So now let's understand by the case law of Vishaka and ORS versus State of Rajasthan and ORS 1997 6 SSC 241. Even before the 2013 Act, the Vishaka guidelines addressed this. The Supreme Court explicitly stated, where such conduct amounts to a specific offence under the Indian Penal Code or under any other law, the employer shall initiate appropriate action in accordance with the law by making a complaint with the appropriate authority. However, action shall be taken against the complainant if the internal committee arrives at a conclusion that the allegation was malicious or a woman made the complaint knowing it to be untrue. The court immediately followed this with a critical caveat. Such action should be taken only after the completion of the inquiry and not during it. This underscores that the primary inquiry is into the complaint itself. The inquiry into malice is a separate subsequent consideration only triggered by overwhelming evidence of bad faith. Section 24, penalty for breach of confidentiality. The integrity of the entire POSH Act hinges on the confidentiality. Section 24 protects the identities and the process itself. What is barred? Publishing or making known the contents of the complaint, the identity and the address of the aggrieved women, respondent, witness, any information related to conciliation proceedings and the finding of the IC. Who can be penalized? Any person, including media houses, colleagues, or even the parties themselves, if they breach confidentiality. Exception: disclosure for the purpose of enforcing the recommendations under the Act is permitted. Now, let's understand what is covered under Section 25, 26, 27. The continuous duties of employer and government. So, as we have understood the penalties, appellate authorities to make the appeal, so we must understand what are the continuous duties of employers and government. The Act doesn't end with a single case. It imposes ongoing obligations to ensure systematic compliance. So, Section 25 says mandatory disclosure in annual report. This is a powerful tool for transparency and corporate governance. For listed companies and large organizations, they must include in their board report, as per the Companies Act 2013, details like number of complaints of sexual harassment received in the year, number of complaints disposed of during the year, number of cases pending for more than 30 days, nature of action taken by the employer. For other workplaces, this information must be provided to the district officer. Now, let's understand what is mentioned there in Section 26. Employer's duty to assess the IC. So, the employer's role is to facilitate this. Section legally obligates them to provide all necessary resources to the ICs to conduct a fair inquiry. This includes securing the attendance of witness and respondent, providing necessary administrative support and infrastructure, making available any relevant documents or evidence in the organization control. Section 27, monitoring by the district officer. This section creates a government oversight mechanism. The district officer, usually the district magistrate, collector, is responsible for monitoring the implementation of this act within their district, compiling and analyzing data from all employers, submitting an annual report to the state government on the number of cases filed, disposed of, and pending, providing a macro level view of the act functioning. Now, Section 28, 29, 30, the supervisory and rule making powers. These sections give the government the teeth to ensure the act is effectively operationalized. Section 28, power to call for information. The district officer or any authorized officer can demand any information relating to sexual harassment from an employer. Failure to provide this information is a violation. Attractive penalties under Section 22. This is an investigative power. Section 29, power to make rules. This is a standard enabling provision that allows the appropriate government, central government offices, territory, state for others, to make rules to carry out the provisions of the Act. The central government has already notified the rules in 2013. Section 30, power to give directions. This employs the central or state government to issue directions to their district officer or any authority to make policies and implementation. This ensures a uniform understanding and application of the law across different states and districts. So, now coming to the conclusion. So, to synthesize Section 21 to 30, create a complete ecosystem. Section 21 provides a corrective mechanism through appeal. Section 22 to 24 provide the deterrent, thorough penalties for specific misstep, and Section 25 to 30 create a framework for ongoing monitoring, transparency, and governance. The case law from Vishaka to Rupali Dev reminds us that this law is a living instrument. It is designed to be interpreted in a manner that balances the fundamental right to a safe workplace for women with the principles of natural justice and fair hearing of the respondent. Understanding these sections in detail is not just about legal compliance, it's about fostering a culture of respect, accountability, and trust within every organization. So, the POSH Act is a shield but also a framework of justice that protects dignity, encourages fairness, and ensures accountability. So, uh, if you found this video useful, do hit like, share, and subscribe to our channel. Comment below with your questions or topics you would like to cover next. Today we have completely covered POSH Act with case laws, and one more big announcement for you in the next video. We are covering question and answers related to POSH Act for revision purpose, so don't miss out the next upcoming video. If the detailed analysis was helpful, please support this effort. Again, I am requesting support this effort by liking this video, subscribing to the channel, and hitting the bell icon so you don't miss the next deep dive. We have videos breaking down the IC formation, the inquiry process, and the critical role of the IC chairperson. And tell which part of the POSH Act would you like to explain us next. Let us know in the comment below. Thank you for watching. Thank you.